Good morning, coffee drinkers. Thank you for tuning in. I'm Hallie Zobel, estate planning attorney here in Orlando, Florida at Private Corporate Counsel. Did you just move to Florida and have a last will and testament executed in another state? I suppose you're wondering if your document is valid. I'm an estate planning attorney, and I get asked this question frequently at my office. As you may know, each state has its different rules for what constitutes a valid will. Wills are not governed by federal law, but state law. So to answer your question, we Florida attorneys must review it to make that determination. We are unable to make that determination on the telephone. Florida can be quite picky about its rules surrounding wills. Our laws want to make sure that the testator, the guy who writes the will, intent is carried out. Therefore, we have strict signing requirements. What are some of those requirements, you ask? Well, the document must be signed at the end by the testator. There must be 2 witnesses who witness him sign the will. That sounds simple, but it's not so simple. The law has been expanded that witnesses can even be remote via video and not in the same room as the testator. This would be for an electronic will. However, that topic is for another day. Although not required by the law, a notary public can notarize the documents if they watch the testator and witnesses sign it and get appropriate ID. This is called a self-proving affidavit. Most Florida attorneys prepare their legal instruments this way, as it makes it easier to admit the will to probate after the death. It is much better to have it self-proven, then we do not have to locate the witnesses years later at the death and have them travel to the courthouse and sign an oath that they witnessed the signing. Witnesses don't want to do that, and I don't blame them. So that being said, many states do not prepare a self-proving affidavit in the will, and it causes difficulty during the probate stage. We probate attorneys have to track down the witness from another state from many years ago who may be deceased and have them to travel to a courthouse to sign an oath. It's difficult and a costly process. It's preferred to already have the self-prove through the witnesses and testator's signatures. It's my advice to go visit a Florida attorney who knows about these type matters and advise on whether you should execute a new Florida will so it will be less stressful and less expensive on the back end. Okay, coffee drinkers, that's all there is for today. Have a terrific day.